civilians in military courts should ensue in very exceptional circumstances and in conditions that genuinely abide the dictates of Article 14 of the ICCPR. It was in January 2006, supplemented with the draft principles governing the administration of justice through military tribunals. The draft principles on military tribunals were rooted in the 1984 General Comment number 13 and must now be construed with due regard for the committee's revised position as encapsulated in the 2007 General Comment number 32. General Comment number 32 demonstrates that the Human Rights Committee does recognize the trial of civilians in military courts, albeit in exceptional circumstances and within established parameters. It calls upon state parties to guarantee the fairness, impartiality, and independence of such trials, which in any event would only be justified in exceptional circumstances and for serious and objective reasons, with appropriate regard for the suitability of civilian courts for the individuals and offenses in question. That is the universally established command of Article 14 of the ICCPR. Courts martial are established by the UPDF Act by dint of Article 210 of the Constitution to preside over the service offenses defined in Section 1 of the UPDF Act, which include the offenses enshrined in Part 6 of that Act. The intricate nature of the service offenses they preside over supports the view that the primary function of courts martial is indeed to foster the efficacy of the military in securing the country and its borders. The enforcement of discipline within its rank and file is a vital component of that objective, but is certainly not the sole function thereof. Be that as it may, the main bone of contention as far as the jurisdiction of the General Court Martial is concerned appears to be the status of that military court in the national judicial system. Black's Law Dictionary defines a competent court, which is interchangeably referred to as a court of competent jurisdiction, as I quote, a court that has power and authority to do a particular act, one recognized by law as possessing the right to adjudicate a controversy, close quote. In the matter before the court presently, the juridical competence of courts martial can be deduced from the definition of a court in Article 257(1)(d) of the Constitution as juxtaposed against Articles 123(b), 137(5), and 257(2)(a)(1) of the Constitution. I find fortitude for this view in the case of Attorney General versus Joseph Tumshabe, where this court adjourned the General Court Martial to be a subordinate court. I therefore abide the position in the lead judgment that the General Court Martial is a subordinate court of judicature within the confines of Article 129(1)(d) of the Constitution. However, the respondent extends his displeasure to the legislature, faulting it for supposedly exceeding its legislative powers when it created the General Court Martial under the UPDF Act and conferred it with criminal jurisdiction over non-military persons and civil offenses. Parliament has a broad legislative mandate under Article 79(1) of the 1 and 3 of the Constitution to enact laws in the interest of national peace, order, and good governance. Article 210(a) and (b) further empowers Parliament to enact laws that govern the UPDF's organs and structures, as well as its discipline. Having found that the General Court Martial is indeed a subordinate court of judicature, it follows that its establishment under the UPDF Act and the delineation of its jurisdiction therein was well within the remit of Parliament. However, the scope of that jurisdiction is a matter of contention before this court. I find that the term service offense in Section 1 of the UPDF Act would encompass the offenses created under Part 6 of the UPDF Act in relation to the persons delineated under Section 1171A to F of that Act, as well as offenses under any other act that are committed by the same category of persons. Hence, the scope of service offenses in question restricts the inclusion of civil offenses to those cases where the civil offenses are committed by persons that are in active military service as delineated under Section 1171A to F of the Act and on field operations. Persons that are not in active military service but only became subject to military law by dint of subsection 1171G and H of the Act would not be tried for service offenses in the military courts. I now turn to the contentious question of the jurisdictional scope of the General Court Martial over civil offenses. I do acknowledge the position taken in Attorney General versus Joseph Tumshabe that there is no provision of the Constitution that restricts Parliament from vesting a subordinate court with jurisdiction that is also within the purview of the High Court. For present purposes, however, I take the view that this lacuna should be interrogated with regard to the special character of courts martial and existing international safeguards in respect of military courts. Principle 8 of the Draft Principles of Military Tribunals considers crimes committed in the course of field operations to be sufficient justification for the trial of civil offenses by military courts. Indeed, Section 198(2) of the UPDF Act does recognize the function of field courts martial in presiding over offenses committed in the course of field operations, I quote, where it is impracticable for the offender to be tried by a unit disciplinary committee or a division court martial, close quotes. This position is reiterated in Section 177 of the Act, albeit with additional emphasis on a civil offense translating into a service offense, whether committed within or outside Uganda. I am alive to the character of courts martial as special courts that are set up to address a specific area of the law, having a more limited jurisdiction than the courts of general jurisdiction, being faster and often not bound to follow the same procedural imperatives, and field court martials are particularly characterized by quick processes that are not unduly bogged down by the procedural imperatives that obtain in general jurisdiction civil courts, or indeed other courts martial, given the peculiar conditions within which they operate. Indeed, the Constitution recognizes the peculiarity of fields court martial when in Article 137(5), it exempts their processes from constitutional references. In those circumstances, closing such field courts martial with jurisdiction over capital offenses that attract a potential death sentence might appear gravely ill-advised, but for the following two critical conditions. First, to restrict field courts martials to non-capital civil offenses would be to leave capital offenses that are committed in those sometimes fluid situations uncatered for and unaddressed. This indisputably would be inimical to the administration of criminal justice and an affront to the rule of law, which subjects all persons to the law. Secondly, Principle 17 of the Draft Principles on Military Tribunals is emphatic on the right of appeal from courts martial, which by extension would include field courts martial. Accordingly, the right of appeal from the decision of a field court martial does provide a vital safeguard to the exigencies of their judicial processes. Its relegation to creation by subsidiary legislation is a misnomer that ought to be revisited. In the event, I would abide the proposition in Principle 8 of the Draft Principles on Military Tribunals that the circumstances under which field courts martial operate do provide sufficient justification for their jurisdiction to try civil offenses, including capital offenses. Having so held, and considering that the General Court Martial sits in appeal over decisions of field courts martial, I would refrain from excluding civil capital offenses from its jurisdiction. I now turn to the constitutionality of Section 1171G and H of the UPDF Act. The controversy as to the constitutionality of those statutory provisions has arisen in numerous cases with varying results. It now falls to this court, under the present appeal, to pronounce itself with finality on the matter. The fundamental question is whether the parameters that are encapsulated in Section 117, 1G and H amount to exceptional circumstances that would justify the trial of civilians in military courts. The law is a major component of public policy and would thus be vital public policy consideration for the justification of the trial of civilians in military courts. Indeed, I am alive to the duty placed upon Ugandan citizens under Objective 29 and Article 3(4) of the Constitution to uphold and defend the Constitution and the law. This perhaps explains why criminal law considers a person that aids or abets the commission of a crime or has a common intention with others in the commission of a crime is criminally culpable. Reading Section 1171G of the UPDF Act, together with Section 191C of the Penal Code Act, would suggest that a person that aids or abets a serving or active military person in the commission of the service offenses delineated in Part 6 of the Act would be deemed to have taken part in committing the offense, be guilty of the offense if proved, and may be charged with actually committing it. In practical terms, Ayume Francis in Criminal Procedure and Law in Uganda posits that a person who aids and abets another in the commission of a crime may be joined in one charge sheet and tried together with those who actually commit the crime, but the particulars of the offense must clearly indicate the role of the aider and abetter. I take the view, therefore, that criminal culpability by way of aiding and abetting the commission of a service offense is sufficient justification for the subjection of a civilian to military law. I respectfully do not abide the view that such trials should not axiomatically ensue in the civilian courts. In my view, the fact that the principal offender is a person in active military service and charged with a purely service offense warrants the recourse to military courts as opposed to civil courts for the trial of both the principal offenders and their accomplices. Furthermore, the intricate nature of service offenses encapsulated in Part 6 of the UPDF Act would be better suited for trial before military courts rather than civil courts. I would, however, abide the exemption posited in Oxford Dictionary of Law that, and I quote, when a member of the armed forces is charged with conduct committed in that is an offense under both service law and the ordinary criminal law, the trial must, in certain serious cases, e.g. treason, murder, manslaughter, and rape, be held by the ordinary criminal courts and is in fact usually held by them in other cases, close quotes. I would construe this position to draw a distinction between the pure commission by a military person of a service offense on the one hand and a service offense that is also available as a civil offense. In addition, though seemingly restricted to capital offenses, I would extend it to non-capital offenses that accrue as both service offenses and civil offenses. In my view, therefore, the general rule ought to be that military service offenses are only triable in military courts and civil offenses are only triable in civil courts, save for two exceptions. The trial by field courts-martial of military persons that commit civil offenses during field operations, and the trial of service offenses by civil courts, where such offenses do also exist on the ordinary criminal law statute books. I would therefore uphold the majority in the Constitutional Court that civilians that aid and abet military persons in the commission of a service offense do by their actions subject themselves to military law under Section 1171G of the Act. Section 1171H, on the other hand, subjects to military law any person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces or other classified stores. I find no definition in the Act as would guide a reasonable member of the public as to what type of military equipment is the monopoly of the UPDF, let alone what would amount to classified stores so as to avoid the prohibited conduct. Article 2812 of the Constitution considers a criminal offense that is not adequately defined to undermine the right to a fair trial and thus prohibits convictions arising from vague and ambiguous criminal offenses. The need for a precise definition of an offense is associated with the principle of legality that translates into the constitutional principle of void for vagueness. The void for vagueness doctrine essentially requires that a penal statute define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. Thus, legislative provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness. On that premise, therefore, I am unable to endorse the constitutionality of Section 117(1)H of the Constitution. In the result, I find that service offenses as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the legislative mandate of Parliament or the objective of the UPDF under Article 210A of the Constitution. Nor in any case are they inconsistent with Articles 28(1) and 44C of the Constitution. I do additionally find that the provisions of Section 117(1)(g) of the UPDF Act do constitute exceptional circumstances under which the subjection of civilian offenders to military courts would be justified. To that extent, that statutory provision is not inconsistent with the Constitution. I, however, find Section 117(1)(h) of the Act to be void for vagueness and therefore inconsistent with Article 28(12) of the Constitution. I would accordingly resolve ground 1 of the appeal in the affirmative, but respectfully find no merit in either ground 4 of the appeal or the cross appeal. I now turn to grounds 2 and 3 of the appeal. The right to a fair trial is anchored in the principle of judicial independence, which in the Ugandan Constitution is articulated in Article 128. In the same vein, Principle 13 of the Draft Principles on Military Tribunals proposes, I quote, "The organization and operation of military courts should fully ensure the right of everyone to a competent, independent, and impartial tribunal at every stage of legal proceedings. The persons selected to perform the functions of judges in military courts must display integrity and competence and show proof of the necessary legal training and qualifications, and military judges should have a status guaranteeing their independence and impartiality, in particular vis-a-vis the military hierarchy." Close quote. The UN Human Rights Committee additionally enjoins states to take all necessary measures to ensure that such trials take place under conditions which genuinely afford the full guarantees as stipulated in Article 14. The African Commission of Human and People's Rights has similarly adopted the stance that military tribunals must be subject to the same requirements of fairness, openness, and justice, independence, and due process as any other process. Thus, in the Constitutional Rights Project versus Nigeria, it decided that a tribunal comprised of one judge and members of the armed forces could not be considered impartial because regardless of the character of the individual members of such tribunals, its composition alone creates the appearance, if not of impartiality and bias, close quotes. The General Court Martial of Uganda was established under Section 195 of the UPDF Act. It is composed of 7 members, all of whom are appointed by the High Command for a period of 1 year, subject to reappointment by the same appointing authority. Its membership is solely comprised of military persons with no provision whatsoever for their professional qualifications. Neither are such qualifications provided for its reserve members. Therefore, although at any one time the actual members of the General Court Martial could very well possess the requisite qualifications, its de jure composition is purely restricted to qualification on the basis of military service. In Inkao versus Turkey, the European Court of Human Rights, the European Court on Human Rights highlighted the specific factors that would be taken into account in determining the impartiality and independence of military judges. The court astutely identified the crux of the matter as the confidence which courts in a democratic society must inspire in the public, and above all, as far as criminal proceedings are concerned, in the accused. It further deduced the parameters that will support the independence and impartiality of military judges to include the same professional training as civilian judges and the enjoyment of constitutional safeguards identical to those applicable to civilian judges. It additionally expresses concern about military judges being servicemen who still belong to the army, which in turn takes its orders from the executive. And they remain subject to military discipline, and the appointment of these officers is made by army structures for a short renewable term. That decision is most persuasive on the standard of independence and impartiality expected of military judges on military courts. In any event, the concerns expressed in it are re-echoed in Principle 13 of the Draft Principles on Military Tribunals. Paragraph 7 of that draft principle emphasizes equivalence in professional qualifications, ethical standards, and constitutional safeguards between judges in civilian courts and their counterparts in military courts as a safeguard for their independence and impartiality. In the matter before us, the respondent, having pointed to the impugned Section 195 as the legal basis for his misgivings with his trial before the General Court Martial, the evidential burden shifted to the appellant to factually demonstrate the independence and impartiality of that court. Regrettably, such evidence was not forthcoming. I do not accept the appellant's proposition that military courts in Uganda are impartial and independent simply because Article 221 of the Constitution enjoins the UPDF to observe and respect human rights in the performance of its functions. In my view, that constitutional imperative is simply a directional standard for courts martial rather than a factual situation that pertains to them. Consequently, in complete agreement with the lead judgment, I find that the Constitution of the General Court Martial does compromise its independence and impartiality as a subordinate court of unlimited jurisdiction and is to that extent inconsistent with Article 28(1) and 44(c) of the Constitution. In the result, I would resolve ground 2 of this appeal in the negative. On the other hand, under ground 3 of the appeal, the respondent's arraignment before the General Court Martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offense as contemplated under Section 117(1)(g) of the UPDF Act. As was earlier observed herein, a person that aids or abets another in the commission of an offense is deemed to have taken part in the commission of the offense and, if proved, would be guilty of that offense. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing Nakawa Division in Kampala District, and designated as a person subject to military law by virtue of Section 119(1)(g), 117(1)(g) of the UPDF Act. Under count 1 of the charge sheet, the statement of offense is stated as offenses relating to security, contrary to Sections 131(f) of the UPDF Act, while the particulars of offense indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places in Wakiso, Kampala, and Luwero districts, with intent to prejudice the security of the defense forces, contrived a plot to overthrow the government of Uganda by force of arms, close quotes. Although the charge sheet referred to in Section 117, I'll say that again. Although the charge sheet referred to Section 117(1)(g) of the UPDF Act under the description of the respondent, it did not spell out his role in the commission of the alleged service offense. This would indeed amount to a defect. However, not every defect in a charge sheet would make it bad in law and render the ensuing proceedings a nullity. The test to be applied is what the effect of the defect is and whether, if proceedings are concluded, it has occasioned a miscarriage of justice. In this case, no attempt was made to demonstrate any such miscarriage of justice. On the contrary, insofar as the charge sheet highlights the statutory provision that brings the respondent under military law, which is clear on the issue of aiding and abetting the commission of a service offense, the respondent would have been on notice of the nature of offense he was arraigned for. Furthermore, the charge sheet spells out the principal offenders by highlighting their status as persons in active military service. Moreover, borrowing from the civilian courts, under Section 132 of the Magistrates' Courts Act, a court that is faced with a defective charge has a wide discretion to amend it at any stage of a trial. As a similarly subordinate court, that option of amendment of the charge would have been available to the General Court Martial to clarify the specific role played by the respondent in the alleged offense, as well as demarcate who of the persons he was arraigned with were the principal offenders. Consequently, given the procedural reliefs available to him, I do not find the defects in the charge sheet in this case to constitute sufficient reason to declare the respondent's arraignment before the General Court-Martial a violation of the right to a fair trial. However, given the then de jure composition of the General Court-Martial under Section 195 of the UPDF Act, the respondent's arraignment before that military court cannot have been in accordance with the right to a fair trial before an independent, impartial, and fair court, as envisaged in Article 28(1) of the Constitution. I would accordingly resolve ground 3 of the appeal in the negative. This brings me to what would be appropriate remedies in the circumstances of this case, and whether or not they should apply retroactively. Black's Law Dictionary distinguishes true retroactivity from quasi-retroactivity, the former consisting of the application of a new rule to matters that were completed before the rule came into force, and the latter entailing the restriction of a new legal rule to matters pending completion. In Griffith versus Kentucky, the US Supreme Court reiterated its view in United States versus Johnson on the need to apply a new constitutional rule to all criminal cases pending determination in order to uphold basic norms of constitutional adjudication. That case was cited with approval by the Constitutional Court in Mabea versus Attorney General, and I still consider it to be good law. I would thus equally cite with approval the observation in Duke Mabea versus Attorney General that a new constitutional rule in the realm of criminal procedure be applied quasi-retroactively or restricted to cases pending final disposal to avert the dire effect on the rule of law and the administration of justice of full retroactivity. Griffith versus Kentucky additionally posits that unlike the legislature, it is not the function of the judiciary to formulate laws on a broad basis, its role being limited to the declaration of a new rule directly arising from adjudication. This is similarly acknowledged by the Canadian Supreme Court in the case of Skakta versus Canada. That case was relied upon in Fish Eric in the article Choosing Constitutional Remedies by Fish Erickson. The choice of appropriate remedy between severance and reading in, where a statutory provision violates the Constitution, hinges on whether the nature of the constitutional inconsistency entails something improperly included or excluded from the statute. In the matter before us presently, Section 195 excludes such professional competencies in the membership of the General Court-Martial as would mitigate connotations of partiality and non-independence. As such, reading those omissions into that provision might have been the more appropriate remedy, but for the fact that the deference to the competence of persons with a military background was at the time informed by the scarcity of legal professionals in the military, as well as the complexities of securing legal professionals for field courts-martials. This is borne out by the parliamentary debate in respect of the then Uganda People's Defense Forces Bill, as reported in the Hansard of that time. So that reading into Section 195 of the UPDF Act, the constitutional safeguards and membership as the court deems appropriate would be tantamount to the usurpation of Parliament's legislative function by judicial overreach. However, the same SACTA case proposes another constitutional remedy that gives the legislature a chance to craft its own solution. Provision for legislative reform therein would, in my view, address the shortfalls of the previous legislative process and provide an opportunity for the review of the military justice law in Uganda, as has been done in other jurisdictions. This would align it with the independence and impartiality safeguards envisaged in the right to a fair trial under the Constitution. It will suffice to observe here that unlike judiciary-driven reforms that ought to be restricted to matters that were in contention between the parties, legislative reform may holistically address matters that were not necessarily in issue before this court. It might similarly accrue to the right to a fair trial in courts-martials. This would forestall avoidable litigation in respect of related matters and abide the notion of judicial economy. Disposition. The upshot of my judgment is that this appeal partially succeeds while the cross appeal fails. I do abide declarations 1, 2, 3, and 6, orders 3 and 7, as well as the advisory orders D, E, and H as stated in the lead judgment. In the result, I would set aside the judgment and orders of the Constitutional Court and substitute them with the following declarations. 1. The General Court-Martial is a subordinate court of competent jurisdiction within the confines of Articles 129(1)(d) and 257(1)(d) of the Constitution, but its de jure membership under Section 195 of the UPDF Act does undermine its independence and impartiality, and is to that extent inconsistent with the fundamental right to a fair trial enshrined in Article 28(1) and 44(c) of the Constitution. 2. The respondent's arraignment before a general court-martial, the de jure membership of which does not pass constitutional muster, was a violation of his right to a fair trial, and to that extent is inconsistent with Article 28(1) and 44(c) of the Constitution. 3. The provisions of Section 117(1)(g) of the UPDF Act do delineate exceptional circumstances that would justify the trial of civilians in military courts, and is to that extent consistent with the right to a fair trial as enshrined in Articles 28(1) and 44(c) of the Constitution. 4. Section 117(1)(h) of the UPDF Act is void for vagueness and therefore inconsistent with the right to a fair trial as enshrined in Article 28(12) of the Constitution. 5. Service offenses as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the objective of the UPDF Act under Article 210 or the legislative mandate of Parliament under Articles 79, 129(3), and 210 of the Constitution, nor in any case are they inconsistent with Articles 28(1) and 44(c) of the Constitution. I shall pronounce my final order as the quasi-retrospective application of all cases pending before the General Court-Martial in light with Order 2 above. I would respectfully propose the following additional advisory order for consideration. The General Court-Martial be substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court-Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order.
Councillor Laka, during my time, you would have the decency of bowing to a judge.
Yes, we are about to start because we are so much obliged, my lord.
Thank you. Can we have Lady Justice Catherine deliver her judgments?
Thank you, my Lord Chief Justice. I have had the opportunity to read the draft opinion of the Honorable the Chief Justice. He ably sets out the questions for determination before us and has cited the relevant sections of the UPDF Act, Cap 330, and the related constitutional provisions which are said to have been contravened. Please note that the sections of the law I will be quoting are quoted from the immediate past laws of Uganda volumes and also from the most recently published edition. So in my final judgment, you'll find two versions of laws. When I read them, I'll read the one that was probably cited during the hearing. I would allow this appeal in part. The Attorney General lodged an appeal against the decision of the Constitutional Court dated 1st July 2021. The respondent had challenged the competence of the General Court-Martial to try civilians under the Uganda People's Defense Forces Act, alleging that the continuance of these trials violates constitutional provisions, including Articles 28(1), 44(c), and 210 of the Constitution of the Republic of Uganda. The Constitutional Court, being the court of first instance in constitutional matters, heard the petition and decided that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for the UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. As a result, sections 2, which now reads as section 1, sections 1191H, and section 179 of the UPDF Act, which expand military jurisdiction of the courts martial to include civilians and classifies civil offenses as service offenses, were declared unconstitutional for violating fair trial guarantees and exceeding the mandate under Article 210B of the Constitution. Finally, the court found that section 119 is not unconstitutional, provided the person not otherwise subject to military law is tried as an accomplice together with a person who is subject to military law as the principal offender on the same charge sheet. I am abundantly aware of the tension that exists between ensuring unfettered military discipline and compliance with the tenets of constitutional right to a fair trial, which should be available to all human beings, including men and women who serve in the military. This entails a delicate balance on a constitutional landscape which the courts are obligated to navigate. I have, in my judgment, undertaken a synopsis of the historical evolution of courts martial in order to locate their relevance and effect in our current systems. In this regard, I have considered the era of the Romans. While the Roman Empire is often considered one of the most influential and impactful empires in history, most historians would not consider it to have been the greatest empire in terms of sheer size. However, the Romans are credited with codifying and maintaining accurate records. The Roman Empire's legacy of military discipline is notable for its extreme punishments, such as dissemination, where 1 in 10 soldiers were executed for collective disobedience. Collective disobedience included such offenses as mutiny, and mutiny included offenses like tree-sitting, sabotage, among others. Tree-sitting meant that the rank and file of men in the mutiny would choose to sit under a tree and not do any work. Annihilation was the extreme measure historically used to enforce discipline in the rank and file of the Roman army. In the latter years, the Normans emerged following the Romans. The Normans, or the Normandy, introduced trial by combat to settle disagreements over money or chattels, movable or immovable, including land. Participants engaged in physical combat until one was killed or 2 wounded to continue. The loser was hanged, reflecting the belief that God had found them guilty. This particular practice of combat was outlawed in the 19th century, with survivors being charged and tried for criminal offenses. One of the Normandy kings, William the Conqueror, developed military justice and influenced feudal traditions in the United Kingdom, including duels and again, trial by combat. The duel significantly influenced modern culture. The duel was just like the combat, a situation where 2 persons who had a conflict fought it out physically. The duel in our modern days is the equivalent of the adversarial system in the court where lawyers for and against parties do battle. The lawyer's sword today in court is his spoken word. It is a duel of words, but it was a duel in the Norman days. The shire courts were introduced by William the Conqueror and maintained by him. These were courts made up of clergy and local leaders who sat and decided cases and received alms from their salaries. That also explains the lawyers' dressing today. It came from the shire courts. Under William the Conqueror, the principle of resolving disputes within the military hierarchy persisted and influenced courts martial. We'll then go to King Gustavus Adolphus. King Gustavus Adolphus of Sweden formalized military justice with his 167 articles of war, introducing regimental and standing courts martial to enforce discipline and morality. These systems were credited with fairness and morality and hence influenced both Europe and the British military laws. And up to date, there are military academy known as the Gustavus Academy. The Soviet Union. The Soviet Union discipline of its rank and file was enforced through punishments, awards, incentives, and enhanced patriotic zeal. Severe discipline was demanded by Lenin and Stalin to effectively use modern war implements like tanks and airplanes. The punishments in the Soviet Union included drinking restrictions, surveillance, counter-surveillance, and even physical searches. One of the most notorious infractions a Soviet soldier could commit was drunkenness. The persistent inspection and searches of the soldier military personnel frequently made it difficult to smuggle alcohol into their garrisons and posts. A non-fiction writer identified alcohol as the primary cause of disciplinary infractions in the Soviet armed forces, resulting not only in drunkenness, but also in theft, bribery, record falsification, and deliberate damage. Alcohol was used not only to deaden the senses and allow a period of escape from the hardships and pressures of daily life, but was also used to celebrate and commemorate every event. Soviet soldiers and sailors were supposedly only permitted to drink when expressly allowed in accordance with the regulations. The Soviet soldier drank when the opportunity to drink presented itself, in direct violation of disciplinary restrictions. They were so starved of drinking that they resorted to drinking the eau de cologne, eating shoe polish when vodka was unavailable. This infraction, though minor, could lead to severe punishment, including imprisonment or banishment to Siberia. The British military system, originating from the medieval court of the chivalry, involved tribunals. The decline of the court of chivalry led to councils of war, which addressed offenses such as mutiny and desertion. They enacted the Mutiny Act of 1789, which established a legal framework for the courts martial, ensuring discipline while introducing procedural safeguards. Key issues included the struggle for control over the military justice system and the development of military due processes. The American military justice system originated during the Revolutionary War, drawing heavily from the British military codes. Post-World War II dissatisfaction with the wartime military justice led many Western countries to adopt more judicial approaches and procedures in their military justice. The American military justice has often seen the intervention of the US Supreme Court in military matters. The question of the status of the offender are constantly under review. A status of the offender determination by the courts helps in restricting which offender is liable to appear and be tried before a court-martial. Often, the spouse or dependent of a serving officer and a civilian worker connected to the military either lose or have their day in court when found offending. The cases of Milligan or Callaghan, Kinsella, and Curry are but a few examples of judicial review of military justice. The determination of what amounts to peacetime and wartime offenses are interrogated by the civilian courts. Uganda's military justice system. Uganda's military justice system was influenced by the British military law, partly because we were colonized by that country. Fast forward, the 1975 Economic Crimes Tribunal established by the government of the day between 1971 and 79 was established to punish profiteers, hoarders, and others acting against the state's economic interests with penalties including death by firing squad or imprisonment. During the period 1971 to 1979, military tribunals often tried civilians and soldiers alike with little regard for fairness or due process. The system was highly politicized, with military tribunals taking precedence over the civil courts. In its military institutional framework, Uganda borrows heavily from the British, the American, and indeed the Soviet or former Soviet states militaries. We have offices such as the judge advocate and the political commissar, which are vestiges of our non-aligned associations with those countries. I will now move to the matters at hand. Notably, the provisions in Section 119 are at odds with the constitutional guarantees under Chapter 4 and 8 of the Constitution of the Republic of Uganda. The current status of courts-martial in Uganda is that all officers who sit on the General Court-Martial are serving army officers who are appointed by the High Command and are men under authority at all times. This means that the setup of the military courts does not follow a process that gives assurances that they will be independent and will deliver justice without fear or favor. By the very nature of their appointment, the structure and the reporting lines, courts-martial are firmly under the superior command and possible instruction of their bosses. Articles 21 and 28 of the Constitution, which provide for equality before the law and a fair trial, offers the following guarantees. The guarantee for equality. Equality means that all persons who appear before a tribunal or court of law are treated equally regardless of their race, their gender, age, or other factors. Presumption of innocence. That an accused is presumed innocent until proven guilty. Burden of proof. That the prosecution must prove its case beyond reasonable doubt. An independent and impartial tribunal. The trial must be conducted by an independent and impartial tribunal. Opportunity to present evidence. The accused is granted the opportunity to present evidence and to challenge the prosecution's evidence through cross-examination. Right to an interpreter. That the accused has a right to an interpreter if they cannot understand the language being used in court. Protection from self-incrimination. that the accused has protection from being forced to incriminate themselves, right to a public hearing, that the trial shall be open to the public, right to be represented by a lawyer, that the accused has the right to be represented by a lawyer of her choice at all stages of the trial. I have found that the determination of the jurisdiction of the courts martial attracts investigation of the legislative intent of creating it. And I ask the question, was it the intention of Parliament to vest the courts martial with jurisdiction to try only serving officers for committing a service offense, or was it their intention to extend military jurisdiction to civilians? Reverting to the long title of the UPDF Act, it is clear that the application of the law was intended to be restrictive rather than general, as it specifically states that it is an act to regulate the Uganda People's Defense Forces. To this end, Section 197 of the UPDF Act also states clearly that there shall be a courts martial for defense forces. How does this stand with the Constitution? Article 44 of the Constitution provides 4 non-derogable rights. The safeguards given under Article 44 include protection from torture, cruel, inhuman, or degrading treatment or punishment. The second is a protection from slavery and servitude. The third is a right to a fair hearing. And finally, an entitlement to a writ of habeas corpus. Essentially, these 4 rights are established as non-derogable, meaning they cannot be taken away even in emergency situations. When juxtaposed against constitutional provisions, sections 1191G and H and section 179 of the UPDF Act are found to be in contravention with articles 28, 43, and 44 of the Constitution of the Republic of Uganda. The jurisdiction of the courts martial is properly vested where there is a demonstrable connection and causal link between the service offense alleged to have been committed and the status of the offender as an active duty and image bearer of the armed forces. The status of the accused is pertinent in establishing the jurisdiction of military courts over civilians. It cannot be overstated that courts martial present a viable means of implementing military justice in a practical, efficient, and flexible manner. We would borrow from other jurisdictions which make a proposition that national defense mandates an armed force whose discipline and readiness are not unnecessarily undermined by the often deliberately cumbersome concepts of civilian jurisprudence. Yet the dictates of individual liberty clearly require a check on military authority in the conduct of courts martial. The provisions of the American Unified Code of Military Justice with respect to court martial proceedings represent a congressional attempt to accommodate the interests of justice on the one hand, with the demands for an efficient and well-disciplined military on the other hand. Indeed, the true test to be directed toward comparing courts martial with contemporary civilian forums is not that we have improved from an epoch that was said to be unjust, but rather that we are comparing favorably with the current constitutional mandate. So when I talk about the historical evolution of the military justice, the idea is not to say that since things got better, but rather to say where do we stand today? The true test ought not to be that military justice today has a semblance of due process. Rather, the test should be whether the military court-martial as it currently is living up to and can be held against the standards that offer protections for individuals against prosecution, detention, without trial, and do not permit any limitation of enjoyment of rights and freedoms beyond what is acceptable or demonstrably justifiable in a free and democratic society. I find that it is constitutional to create and have general court-martials. Historically, the purpose of the general court-martial was to instill and maintain discipline in the rank and file of the armed forces. To the extent that it exists to discipline and bring justice to its own rank and file, who are in conflict with its laws, its processes, and its procedures, the existence of the court-martial cannot be questioned. Let me conclude on this note. Courts-martial are specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the army courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the courts-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system, and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature, and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court-Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial. I uphold the decision of the Constitutional Court to the effect that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the courts-martial of the cross-appellant stroke respondent and civilians of equivalence under section 1191G, read 1171G, is in breach of articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I would make the following orders. In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial, save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts-martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts-martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts-martial be suspended forthwith. An injunction doth issue restraining the instigation, reopening, or continuance of the respondent's trial before the General Court-Martial or other courts-martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future courts-martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings or movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary courts of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant Ogwang Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. the court called for legal reform and amendment of the UPDF Act in order to enable the courts of judicature to exercise their mandate of judicial review over the courts martial. In this regard, an amendment of the Uganda People's Defense Forces is required to confer appellate jurisdiction to the apex courts for them to be able to lawfully entertain appeals from the courts martial. The other question Ogwang raises is a requirement to delimit what a service offense is during peacetime. I propose that a soldier who commits a civilian offense when he is off post and away without pass leave or a wall should be arraigned before the civil courts, civil as opposed to military courts. The cross appeal succeeds. The main appeal succeeds in part. I make no order as to costs.
I call upon Lady Justice Elizabeth Musoka to deliver her judgment. You will please bear with her. I think she's got a little cold, so she needs your patience and understanding, my lord.
I hope you hear me. My voice is a bit coarse, but this is a summary of my judgment. The judgment will be provided as the leader of this panel. The head of the panel will advise. The appeal and cross appeal in this case, again, is the decision dated 1st July 2021, rendered by the Constitutional Court. The quorum of Kakuru, Obura, Madrama, Musota, and Kasule acting judges of the Constitutional Court. That is Michael Kabaziguruka, Honorable, that's as Attorney General. The Attorney General is the appellant, stroke cross respondent, and Honorable Kabaziguruka is the respondent cross appellant, stroke cross appellant. The particulars relating to the declarations and orders sought in the respondent's petition, the issues identified for determination by the Constitutional Court and its decision on those issues, as well as grounds of appeal and those of the cross appeal, have been set out in detail in the judgment of the Honorable the Chief Justice, which I've had the opportunity to read in draft. I also had the opportunity to read the draft, the judgment of the judgment of Mogenyi, Justice of the Supreme Court. And in the interests of brevity, I'll straight away go into a discussion of the findings in my judgment. However, before giving my views, I should say that when the respondent filed his petition on 17th November 2016, he was challenging certain provisions of the UPDF Act of 2005. Under the 2023 revised edition of the laws, where the UPDF Act is now cap 330, the numbering of many of the impugned provisions has changed, as indicated in the judgment of the Honorable, the Chief Justice. Nonetheless, in this judgment, I make reference to the numbering of the relevant provisions as set out in the respondent's petition and the judgment of the Constitutional Court. Although for future purposes, the numbering contained in the revised act should apply. My judgment, and I said I'm giving a brief, a summary of it. As I have indicated in my judgment, which you'll get, the grounds of appeal and cross appeal, in my view, raise the following questions for this court's determination. Whether the 1995 Constitution places limits on the jurisdiction that Parliament can confer on the General Court Martial and the other military courts, and if so, what is the scope of those limits? Whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond the applicable constitutional limits. Whether the General Court Martial is a subordinate court within the meaning of Article 129(1)(d). Whether the General Court Martial had jurisdiction to conduct the arraignment of the respondent, and if so, whether the arraignment contravened the respondent's right to a fair trial. Whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44C. And lastly, what are the appropriate remedies to grant in this case? My perspective on these questions is as follows. The first question being on regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that the 1995 Constitution under Article 2010B limits the jurisdiction that Parliament may confer on any military court to only matters falling within the sphere of discipline and removal of members of the UPDF. This implies that the nature of cases that may be tried by the military courts are limited to disciplinary offenses committed by members of the UPDF, and the nature of punishment that can be imposed for such offenses is limited to the disciplinary sanctions, which are also provided, which are dismissal with disgrace, reduction in rank, forfeiture of seniority, suspension, severe reprimand, and caution. So for the analysis of the first question, you'll find that analysis on pages 2 to 10 of my judgment. Second question, in relation to the second question of whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond any applicable constitutional limits, I find that it does in many respects as follows. First, in respect of Section 2 and Section 119(1)(a) to F of the UPDF Act, which conferred jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offenses under Part 6 of the UPDF Act. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, insofar as the punishments prescribed for Part 6 offenses are not only limited to discipline sanctions, the only punishments that can be imposed by military courts under 2010, but include serious punishments like the imprisonment and the death sentence. Second, in respect of Section 2 of and Section 179, which confers jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offenses under the Penal Code Act and other enactments. The jurisdiction also goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that punishments prescribed under the relevant laws are not limited to only disciplinary sanctions. The only punishments that can be imposed by the military courts under Article 2010. But they include serious punishments like imprisonment and death sentence, as I said. Thirdly, in relation to Section 2 and Section 1191G, which confer jurisdiction on the General Court Martial and other military courts to try non-members of the UPDF who are alleged to have aided and abetted members of the UPDF in commission of Part 6 offenses. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that the category of persons covered by this jurisdiction are not members of the UPDF, in respect of whom Article 210B was intended to cover. In addition, as with the first two categories, the jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF because the prescribed punishments for Part 6 offenses, which include the imprisonment and death, are more severe than the disciplinary sanctions, which can be meted by the military courts under Article 2010B. Fourthly, with respect to Section 1191H, which grants jurisdiction to the General Court Martial and other military courts to try non-members of the UPDF who are found in possession of prescribed military equipment, this jurisdiction also goes beyond the sphere of discipline and removal of the UPDF, members of the UPDF, for three reasons. First, the persons affected are not members of the UPDF who fall within the jurisdiction of the military courts. Secondly, Section 1191H appears to be a penal provision, but it does not prescribe a punishment. And thirdly, the punishment for analogous offenses under other laws include terms of imprisonment, which fall outside the nature of punishments that can be imposed by the military courts under Article 210B, which are limited to disciplinary sanctions. In light of these observations, I find that Section 2, Section 1191A to H, and Section 179 all grant jurisdiction to the General Court Martial and other military courts, which is inconsistent with Article 209A and 210B, and therefore, to the extent explained, unconstitutional. and null and void. For the fourth category, which is provided for under section 1191H of the UPDF Act, I find that it does not fall under the sphere of discipline of the UPDF, as it is neither concerned with members of the UPDF nor with disciplinary sanctions that can be given to members of the UPDF for engaging in unacceptable conduct. For analysis, the analysis of the above second question will be found on page 10 to 15 of my judgment. The third question, it's with respect to the question of whether the General Court Martial is a subordinate court. I note that Parliament is required to enact legislation under Article 129(1)(d) for the creation of a subordinate court. But for the General Court Martial, Parliament moved under Article 210(b) with an intention to create a disciplinary body for the UPDF, not a subordinate court. I also find that in any case, going by the provisions of Article 210(b), the framers intended that military courts could only be established as disciplinary organs of the UPDF and could not be vested with a general judicial function so as to leave room for their establishment as subordinate courts. In addition, I find that a court can only qualify to be called a subordinate court if it's subject to the supervision of a superior court through revision proceedings. And note that the General Court Martial is not subject to the supervision of any of the superior courts under Article 129(1), including the High Court, Court of Appeal, or Supreme Court. And I conclude that on this account alone, cannot be stated that the General Court, in my view, that the General Court Martial is a subordinate court. I also find that it's not a subordinate court because it lacks essential features found in other courts of judicature, such as competence of its officers as legal professionals and lack of independence and impartiality. With all due respect, I propose the overruling of the dictum of Mulenga JSC in this court's decisions in Attorney General versus Joseph Tumshave and Attorney General versus Uganda Law Society. Citations are given, in which Mulenga JSC expressed the view that the General Court Martial is a subordinate court within the meaning of Article 129(d). Because in my view, that dictum was erroneous. I also point out that the Joseph Tumshave case was concerned with the version of the GCM of the General Court Martial under the now repealed UPDF Statute number 3 of 1992, enacted before the coming into force of the 1995 Constitution, which makes it distinguishable since this appeal is concerned with the version created under the UPDF Act 2005. I therefore find that in the present case, this court does not have the same liberty to characterize the General Court Martial, since when Parliament enacted the UPDF Act, which provides for the current version of the General Court Martial, it could only establish a disciplinary body for the UPDF under Article 2010A and B. The third question, the analysis of the third question will be found on pages 15 to 19 of my judgment. Now, the fourth question regarding the constitutionality of the respondent's arraignment. I note that in light of the position taken in my judgment, that under Article 2010B of the 1995 Constitution, the General, the General Court Martial is limited to hearing cases involving members of the UPDF. And I take the view that since the respondent was not a member of the UPDF at the relevant time, his arraignment was unconstitutional. For the analysis on the fourth question, see page 17 of my judgment. Fifth question, in relation to the fifth question, whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44C, I express the view in agreement with the views expressed in the respective judgments of the Honorable the Chief Justice and Mugenyi, Justice of the Supreme Court, that there exists several deficiencies in the setup and operations of the General Court Martial that diminish its capacity to properly adjudicate cases. And these include objective lack of independence of both the General Court Martial as a court and of its members as individuals. The lack of competence of the members due to their lack of legal knowledge and the absence of effective mechanism for reviewing the correctness of the decisions of the GCM, of the General Court Martial. I note that our constitution was put in place to ensure a just, free, and democratic nation which encourages respect for people's fundamental rights, which was the reason for establishing the courts of judicature under Chapter 8 and vesting them with the mandate to exercise judicial functions fairly and do justice in all cases. I note that for criminal trials, the needs of justice require that accused persons are tried before competent courts or bodies that are capable of guaranteeing the right to a fair trial, and that unfortunately the deficiencies highlighted above render it impossible for an objective observer to conclude that the General Court Martial can guarantee the right to a fair trial. And as it is well known, a fair trial is a vital prerequisite for ensuring justice in criminal cases. Therefore, I find myself in complete agreement with the analysis and views of the Honorable Chief Justice and Genyi JSC on the deficiencies in the General Court Martial and how they render it incapable to accord a fair trial to the people that fall within its jurisdiction. In light of the highlighted deficiencies, I express the view that it is necessary not only to give a strained construction of the matters that properly fall within the ambits of discipline and removal of members of the UPDF, but also to ensure that as far as possible, offenses are tried by courts of judicature, not military courts. I further express the view that it is therefore inappropriate to grant the military court's jurisdiction beyond the trial of members of the UPDF for disciplinary offenses under Part 6 and the imposition of disciplinary sanctions as punishment for those guilty of disciplinary offenses. All other criminal matters ought to be handled by courts of judicature. However, even in cases involving disciplinary offenses under Part 6, there should be established a mechanism providing for review vision of the decisions of military courts by the courts of judicature to ensure that the ends of justice are met. In my judgment, I exhort the learned Attorney General to take interest in the best practices set out in the respective judgments of the Honorable the Chief Justice and Mugenyi JSC, which represent the best reforms to improve the military court system. These are found on pages 19 to 20 of my judgment. In conclusion, and for the reasons given in my judgment, which you'll get, I would disallow all grounds of appeal and allow the sole ground of cross appeal. I would make I'll take on the declarations numbers 4, 5, 6, 7, and 9, and orders 1, 2, 3, 4, 5, and 7 contained in the judgment of the Honorable the Chief Justice, since they are consistent with the findings in my judgment. I would also commend the Honorable Chief Justice's advisory orders to the attention of the learned Attorney General. I would then make the following separate declarations arising from the findings in this judgment, in addition to the ones I have pointed out above contained in the judgment of the Honorable the Chief Justice. Number 1, General Court Martial is not a subordinate court within the meaning of Article 129(1)(d) of the 1995 Constitution. General Court Martial and other military courts are disciplinary organs of the UPDF established under Article 210, whose jurisdiction is limited by Article 210(b) to handling matters related to discipline and removal of members of UPDF, including former and assimilated members of the UPDF, as stipulated under Section 1191A to F of the Act. Number 3, the jurisdiction of the General Court Martial and other military courts is under 210(b), limited to hearing matters involving disciplinary offenses under Part 6 of the UPDF Act, committed by members of the UPDF as defined in paragraph B, and is also limited to the imposition of disciplinary sanctions to the members of the UPDF found guilty, as I have already stated. I enumerated the offense, the punishments earlier on. Jurisdiction of the General Court Martial and other military courts does not extend to hearing cases involving civilians who are neither former or assimilated members of the UPDF, as defined in paragraph B. The hearing of cases involving civilian non-members of the UPDF falls within the jurisdiction of courts of judicature established under Chapter 8 of the 1925. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of offenses under Part 6, the Act, and where it is appropriate to impose a sentence of imprisonment or a more serious sentence, falls within the jurisdiction of courts of judicature established under Chapter 8. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of general civilian offenses created under any enactment other than Part 6 of the UPDF Act, falls within the jurisdiction of the courts of judicature established under Chapter 8, the Constitution. Section 2, 1191 H and G, and Section 179 of the UPDF Act, in as far as they confer jurisdiction on the court martial and other military courts to the constitutional limits, contrary to the constitutional limits described above in this judgment, are unconstitutional, null and void. I would make the following orders in addition to the ones which I adopt from the Honorable the Chief Justice, which are in his judgment orders, in the draft judgment which I read. There were orders 1, 2, 3, 4, 5, and 7. I would just add that going forward, only cases involving members of the UPDF and related to disciplinary offenses under Part 4 of the UPDF Act should be tried by the general court martial and other military courts, and that only the disciplinary sanctions as described at C above can be imposed by the military courts in those cases. Number two, where a military court determines that the imposition of a more serious punishment, such as imprisonment or the death sentence, is necessary, in addition to removal from service, the military court shall forward the case file to the Director of Public Prosecutions with a recommendation for institution of criminal proceedings in a competent court of judicature. I'll adopt the order made by the Chief Justice on the respective effect of, or otherwise, of this judgment. Otherwise, I would award costs of the appeal and the cross appeal in this court and the costs in the Constitutional Court to the respondent.
Now we'll now have Honorable Justice Mike Chibita deliver his judgment.
Thank you, Honorable Chief Justice, my lords, ladies and gentlemen. I've read the lead judgment of Winyidolo Chief Justice in drafts. On the whole, I agree with the spirit, findings, declarations, recommendations, and orders. Before delving into the substance of the judgment, let me deal with one preliminary point of public interest. As one of the surviving members of the original panel that first heard this matter, I reiterate the explanation that unprecedented occurrences indeed hindered and stood in the way of the expeditious disposal of this appeal. The retirement of Honorable Justice Ezekiel Mhanguzi and the deaths of Honorable Justices Opio Aweri and Stella Rach Amoko, all of whom were members of the original panel, ensured that reconstitution of the panel was inevitable. It was not until Honorable Justices Catherine Bamgemereire and Monica Mugenyi, Justices of the Supreme Court, were appointed in 2024 that a full panel could finally be reconstituted. Suffice to say that any delay in dispensing justice is always regrettable, whatever the cause. The larger principles at play in this case are the age-old principles of the jurisprudence of criminal law. It is universally accepted in the common law system to which Uganda subscribes that the presumption of innocence is a bedrock of our criminal law. And this has been incorporated in the 1995 Constitution of the Republic of Uganda under Article 28(3)(a), which states that every person who is charged with a criminal offense shall be presumed to be innocent until proved guilty or until that person has pleaded guilty. In other words, everybody is presumed innocent until proven guilty by a competent court. What we are investigating in this case is whether the court-martial is a competent court to try civilians or anybody else brought before it for that matter. Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution, which reads, in the determination of civil rights and obligations or any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law, close quotation. So the question is, does the General Court-Martial guarantee these fundamental freedoms? The answer, as far as civilians are concerned, has been found to be largely in the negative. In accordance with the doctrine of precedent and in view of an earlier holding by this court, the conclusion in Attorney General versus Joseph Tumushabe that the General Court-Martial is indeed a subordinate court as contemplated under Article 129(1)(d) of the Constitution is still good law. Secondly, that Section 117(1)(g) of the UPDF Act does constitute exceptional circumstances under which the trial of civilians in military courts would be justified, and to that extent is not inconsistent with Articles 28(1) and 44(c) of the Constitution. However, I agree that Section 1171(h) of the Act is to be found void for vagueness and therefore inconsistent with Article 28(1) of the Constitution. On the issue of remedies regarding matters pending before the General Court Martial involving civilians, I would agree that they will be remitted to the civilian courts for consideration. And in regard to trial of members of the military, I agree with the recommendations given to the executive and parliament to work on the necessary amendments in order to bring the court martial in conformity with the Constitution. I'm persuaded by the doctrine of prospective annulment as opposed to retrospective annulment, as laid down in the case of Calista and Rumatela and two others against the East African community, which was applied in the case of Bob Kasango against Attorney General. The same principle was held in the case of East African Law Society and four others against Attorney General of Kenya and three others. The court declined to invalidate amendments found to violate the treaty. Court, however, invoked prospective annulment and declared that involvement of the people in the treaty amendment process would have prospective application. In the case of A against the governor of Abba Hill Prison, the Supreme Court of Ireland held that the declaration of unconstitutionality of a law has prospective effect only. It was further held that the court cannot interfere with final decisions of the courts, even if based on a law later to be found unconstitutional. Otherwise, retrospective annulment or retrospective effect, as termed elsewhere, would create an absurdity, which the courts can and should never intend. Dated at Kampala, the 31st day of January, 2025.
Now we can ask Lady Justice Twice to deliver her judgment.
Thank you, my Lord. Thank you, my Lord Chief Justice. I will proceed to read my judgment as follows. I have had the benefit of reading in draft the lead judgment by Alphonse C. Owindolo, Chief Justice. I agree with the analysis, decisions, conclusions, and orders that are proposed in his lead judgment. The background to this appeal and the respective cases for the parties to the suit have been ably articulated in the lead judgment and in other judgments prepared by my land sisters and brothers in this appeal, which I have also had the benefit of reading in draft. It is therefore not necessary to reproduce the same. I will only add my opinion regarding the issue relating to the capacity of the I will only add my opinion regarding the issue relating to the capacity of the General Court Martial to render a fair trial as envisaged in Article 28(1) of the Constitution of Uganda. The jurisdiction and competence of the said court is challenged by the respondent in this appeal. The appellant, on the other hand, contends that it is a court of competent jurisdiction provided for under Article 210 of the Constitution of Uganda and Section 197, now 195 in the revised edition, the year 2023 of the Uganda People's Defense Forces Act. The appellant also, in opposition to the respondent's assertions, contends that the establishment of the General Court Martial does not contravene Articles 28.1, 126.1, 129.1, 210 and 267.1d of the Constitution of Uganda. The General Court Martial is created under Section 197, now Section 195 in the revised version of the laws of Uganda, of the Uganda People's Defense Forces Act. Its long title reads, among other things, that it is an act, I'm quoting, to provide for the regulation of the Uganda People's Defense Forces in accordance with Article 210 of the Uganda Constitution and for other related matters. It is a specialized court in the sense that it was created to exercise jurisdiction over specified matters relating to offenses created by the UPDF Act, committed by members of the military forces and persons who aid or abet such offenses. In short, to administer military justice in Uganda with jurisdiction to handle offenses specified in the Act, mainly for penal and disciplinary purposes. The General Court Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Cadiz courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament, to the Supreme Court, the Court of Appeal, and the High Court shall be superior courts of record and shall each have all powers of such court. And 3, subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, the courts martial are set up by an act of Parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial set out under Section 100 and 95 in the revised version of the laws of Uganda 2023 of the UPDF Act is that they should essentially be army officers, with the chairperson not being below the rank of a lieutenant general, save for the chairperson of the court of the court martial appeal court, who is required to be an advocate qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military court setup under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified for appointment as judicial officers to the courts of judicature, as established under Article 129 of the Constitution of Uganda, must have legal qualifications. It is to be noted that both the General Court Martial and the courts of judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law would pass. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court martial. The contradictory position is that while under the UPDF Act, qualification for appointment to the General Court Martial does not require one to have legal qualifications, persons qualified for appointment to the position of a judicial office in the courts of judicature are required to have legal qualifications under Article 142 of the Constitution. Secondly, the conducting of criminal trials in the General Court Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications. The criminal prosecutions conducted before such courts should ideally be controlled by the Director of Public Prosecutions. This would be a safeguard for a fair trial envisaged under Article 28(3) of the Constitution of Uganda. In addition to the International Covenant on Civil and Political Rights, to which Uganda is signatory, and all other international human rights instruments, binding or persuasive, which have been ably highlighted in the other judgments to this appeal. In my considered opinion, it would not matter whether in actual fact, that is de facto, The members appointed to sit on the General Court Martial, in the wisdom of the appointing authorities, do possess the legal qualifications to be competent to adjudicate criminal matters, especially those attracting heavy penalties. As long as the UPDF Act that creates the General Court Martial does not expressly include legal qualifications as a requirement for appointment to the General Court Martial, that is de jure, the competence and capacity of that court to handle criminal trials would still be questioned as is being done in this appeal. This is based on the cardinal principle in our legal system that justice must not only be done, it must be seen to be done. The General Court Martial would only be competent to adjudicate over criminal matters of not only civilians, but also military persons, if it were a court of law with the requisite structures to conduct a fair hearing, as envisaged under Article 28 of the Constitution of Uganda. There can be no fair trial as envisaged in Article 28(1) of the Constitution in an incompetent court. It is in that regard, I would, with respect, not agree with the appellant's contentions that the General Court Martial is a court of competent jurisdiction to hear criminal matters. In its present state, the General Court Martial, though lawfully set up by an act of parliament, deriving such powers from Article 129(1)(d) of the Constitution, is in its present form competent only to handle matters relating to discipline of members of the armed forces. In the result, based on the above, and in addition to the reasons, decisions, conclusions, and recommendations for legal reforms stated in the lead judgment, which I associate myself with, I would conclude that this appeal fails, save for the issue regarding the establishment of the General Court Martial as a court of law. I would dismiss it to that extent and allow the cross appeal. I would award the course of this appeal to the respondent in this court and in the courts below.
Thank you, my lord. I propose we take a 10 minutes health break.
Yes, my lord.
Yes, because 200 pages will take us up to midnight, I think. So, okay. So 10 minutes break, health break, yes.